Welcome to Term Talk, the video podcast from the Federal Judicial Center that analyzes Supreme Court decisions from each term likely to have the most impact on lower courts. I'm Francesca Williams, education attorney for executive education at the Federal Judicial Center. Joining me to do that are Laurie Levenson, professor and David W. Burcham chair in ethical advocacy at Loyola Law School, and Evan Lee, Emeritus professor at University of California Law, San Francisco. Thank you both for being here today. Chiaverini v. City of Napoleon explores whether to support a 1983 claim, all charges must be malicious. Laurie, can you explain the issues and the facts of this case?
Yes, Francesca, there are actually two big issues in this case. The first issue was, does the Fourth Amendment allow the cause of action for malicious prosecution? Now, that issue was decided a couple of years ago in 2022 in Thompson versus Clark. And in that case, they went through and they said, indeed, you can bring such a claim as a violation of the Fourth Amendment, because if you were maliciously arrested and prosecuted, you're being detained under the Fourth Amendment. But there was a second major issue as well. Does the existence of some legitimate charges against the defendant insulate against a claim for malicious prosecution because there might have been some illegitimate ones? And if so, under what circumstances, and how do we analyze the causation? Now, the way that worked out under the facts of Chiaverini's case is that he owned a jewelry store, and the police came to him and he refused to return a ring. In conversations with the police, he mentioned that he was operating the store without a license. He ended up getting charged with a couple of misdemeanors, receiving stolen property and dealing in precious metals without a license, but he also got charged with a felony of money laundering. And the arrest warrant actually focused primarily on the money laundering, saying that Chiaverini always suspected it was stolen. He spent 3 days in jail after being arrested, and after that, the prosecutors decided not to pursue the charges. They had other priorities, and he was released. But he turned around and sued the officers for malicious prosecution. He disputed that he had said or knew that the property was stolen, and he said that the value didn't meet the threshold anyways. The Sixth Circuit affirmed what had been a summary judgment for the officers, saying that because there was probable cause for some of the charges, he couldn't contest whether the felony charge was malicious prosecution. And there had been a circuit split on this type of issue. This case goes up to the Supreme Court, and it's 6-3 decision, and it's interesting. By the time it got to the Supreme Court, both the government and Chiaverini agreed that, in fact, he could bring the action. So the court appointed an amicus, and the Supreme Court did say that the validity of some charges does not insulate the other charges from a malicious prosecution claim.
Thank you, Laurie. That is interesting. Evan, can you walk us through a bit how the court came to the conclusion?
Yeah, well, as Laurie said, as for the pinpoint issue in this case, whether the presence of probable cause supporting some charges insulates the remaining charges from a malicious prosecution action, that was really already decided because everybody, all the parties agreed on it. The amicus agreed on it, and the court, of course, agrees with them. But the real issue in this opinion is the continued validity of Thompson versus Clark, which is the case that holds that a malicious prosecution action under Section 1983 does lie under the language of the Fourth Amendment. And in this opinion, the majority reaffirms that strongly, finds that the analysis supports Thompson versus Clark's conclusion that pretrial detention without probable cause is an unreasonable seizure and therefore implicates the Fourth Amendment. There is also discussion in this opinion of the causation issue. That is to say, did the officers allegedly, malicious prosecution conduct cause the unreasonable seizure, cause, in this case, the 3 days of detention in jail? There are a number of different legal tests for causation that could be applied to that. A but-for test, a so-called bad apple test, maybe other possible tests, but the court doesn't get into it in detail because it says in this posture, the causation issue is not properly presented. And so it remands to the Sixth Circuit for a first look, for a first pass on that causation issue.
Thank you, Evan. Would you also speak to the dissent's analysis here?
Yeah, so Justices Thomas and Alito dissented strongly. They said Thompson versus Clark was wrongly decided. It should be overruled. And that's why there's so much really sort of parrying in the court's majority opinion, defense of Thompson versus Clark, because this dissent by Thomas and Alito is a full-on, head-on assault against Thompson versus Clark. And the analysis of the dissent is, look, the elements of common law malicious prosecution simply don't match up with the elements of unreasonable seizure under the Fourth Amendment. Malicious prosecution protects against the initiation of charges, not against detention. Furthermore, they say unreasonable seizure does not and should not depend on the motives of the officer. And they say that under common law malicious prosecution, the resolution of the charge doesn't matter. But there is another opinion in this case, and it was written by Justice Gorsuch. And although he agrees with some of what Justices Thomas and Alito said, he certainly does not agree with all of it. He agrees that Section 1983 should not be regarded as a so-called font of tort law. He also agrees with them on the question of whether Thompson versus Clark is correct or incorrect in locating a malicious prosecution action in the Fourth Amendment unreasonable seizure language. He agrees with them that that's not a hospitable home for a malicious prosecution action. But breaking with Thomas and Alito, he says the 14th Amendment's due process clause may very well be a congenial home for a malicious prosecution action under 1983. And so he's definitely leaving that open for the future.
So, Evan, in a nutshell, what are the takeaways?
Well, I mean, you have 6 solid votes for the continuation of Thompson versus Clark. You have 2 solid votes to overrule it, and you have 1 vote to relocate malicious prosecution under Section 1983 from the Fourth Amendment to the 14th Amendment due process clause. And, then there's just the basic black letter law that comes out of this case, which is just because you've got 1 or more charges that are supported by probable cause, that doesn't mean that charges not supported by probable cause can't give rise to a malicious prosecution action.
Thank you. Laurie, would you close us out with anything you'd like to add?
Well, as Evan has said, I think this issue was decided by Thompson, but it was necessary to go to the Supreme Court because we had a split in the circuits on it with regard to whether the continuing detention because of charges, some of which were valid, some which were not, would lead to a cause of action. Now, the frontier on this is, of course, determining causation. We don't know how that will come out yet, because the lower courts have to address how will they deal in these mixed cases with the question of causation.
Well, thank you both for joining us and helping us sort through these complicated issues.